This series explores various issues that are of interest to Catholic thinkers and policy issues, and we explore different contentious issues from a variety of perspectives. Sometimes it's a clash of different faith perspectives, sometimes it's a clash of different positions on the same topic that lead to different kinds of results, and sometimes it's not. In this case, it's a topic that is of intense interest to the Catholic Church. In the words of our Pope Francis, way back in May 16th, one of the first speeches he made that caught a lot of attention contained this line: "The financial crisis which we are experiencing make us forget that its ultimate origin is to be found in a profound human crisis. In the denial of the primacy of human beings, we have created new idols. The worship of the golden calf of old has found a new and heartless image in the cult of money and the dictatorship of an economy which is faceless and lacking any truly humane goal." We have three incredible experts in the face of crime who are going to be speaking to us today and putting faces to some of the people who are involved in the financial crisis. Our moderator today is our very own Professor Mark Osler, who teaches criminal law and various other criminal-related courses for us. Mark is also an influential figure in shaping criminal law. The law itself, in terms of the cases that he's been involved in, Spears v. the United States, where he successfully convinced the Supreme Court that sentencing judges should be able to categorically reject the 101 ratio of crack in sentencing for crack versus powder cocaine. And it was also influential in the Booker case, striking down mandatory guidelines as well. He's also shapes people's hearts and minds in the work that he does on the death penalty in campuses and churches throughout the nation. So I'm going to turn the whole program over to our moderator, Mark Osler. When you have questions, put them on these little cards that are the end of every row, and we'll start gathering them halfway through the debate in order to start be prepared to ask questions after we end. So Mark Osler.
Thank you. Well, I would say that in the company of the two gentlemen we're going to hear from as the true experts today, I hardly qualify as a former federal prosecutor. Joe Dixon, who is here to your left, served as the chief of the Economic Crimes Unit of the U.S. Attorney's Office here and was renowned for his work on high-profile cases against Tom Petters, Trevor Cook, Denny Hecker, and many other people and organizations. He also has considerable experience in the private sector and currently is Deputy General Counsel at United Health Group. He's a graduate of Columbia Law School, and we're very fortunate to have him as an adjunct here at the University of St. Thomas, where he's taught both evidence and white-collar crime. I know how good he is because my students quote him to me a lot as I'm teaching. And
hopefully for correct propositions.
It's always been correct, yes. So I've been very, very impressed because not only is he teaching them the right things, but they're remembering it. So it's wonderful to have you here. To his left is Professor Hank Shea from here at UST. He is also a former AUSA. He also was at one time the chief of the Economic Crimes Unit in the U.S. Attorney's Office. He served for 4 years in the U.S. Army after his graduation from Harvard Law School. Personally, I can say that the fact that Hank Shea was here is a major reason that I came to teach at the University of St. Thomas. I was asked to come up here and give a lecture to the faculty, to a colloquia. And I asked one of my students at Baylor, who I was teaching at the time, to prepare a notebook of the faculty members so that I would know my audience. I still have it. It's right here with all the side tabs. And I remember being so amazed at the talent of the faculty here. But when I got to the S's and I saw Hank Shea's name, you can see I wrote Hank Shea in big blue marker. And that's because as a prosecutor, as someone who studied criminal law, Hank Shea was fairly legendary for the work that he'd done, for the difference that he'd made, and for the example that he'd set for others. And so we're very fortunate to have both of them here today. Professor Dixon is going to be taking the position that the Department of Justice should have done more to address the recent financial crisis, particularly through the prosecution of individuals. Professor Shea will take the opposing view, although there may well turn out to be some overlap in some of their positions. We're going to give each about 10 minutes to set out their positions at the start, and then once we've had that first round, about 5 minutes more from each of them to respond to the other. And after that, we'll open up to your questions, which we'd ask that you write down on the cards that you've been given, and then we'll collect them that way. Mr. Dixon.
Thank you. Thanks very much, Mark.
Thank you very much for being here today, and thanks for this opportunity. I'd like to start with a proposition, a value proposition that I have, and it sort of colors how I think about this. But in my view, and I don't think this is going to be a shock, people who commit crimes should be prosecuted. That's sort of my value, and I want to start with that. And particularly when people who commit crimes that have a significant societal impact and significant societal harm, those people really need to be prosecuted. It's important for deterrence. It's important for confidence in our institutions, and it's important for our sense of justice, at least in this country. In the past, we've had financial crises. The crisis of 2007, 2008, and all the cases that came out of it or didn't come out of it, that we have faced financial crises in the past, and the Department of Justice has met those challenges. I mean, Hank Shea was one of the prosecutors who met those challenges in past crises. The Enron collapse was dealt with effectively by the Department of Justice. The WorldCom case was a complex crime committed by executives in the WorldCom company. And the crisis that I want to focus a little bit on is the savings and loan crisis of the late 1980s and the early 1990s. And I think it's worth remembering what brought us to that crisis. There was rapidly rising real estate prices in a bubble sort of economy. Financial institutions became less regulated and were taking riskier and riskier positions. Those risks were not disclosed to investors by financial executives. It sounds awfully familiar, really. It sounds awfully familiar to what we've just been through. And coming out of the bursting of the bubble, a swath of financial institutions, hundreds of financial institutions failed, and the taxpayer bailout was in the billions of dollars. Again, very familiar. What was different in the early 1990s? Over 1,000 bank executives were criminally prosecuted. Charles Keating among them, that's probably one of the best known cases, as well as locally the Midwest Federal case, prosecuted by our own Hank Shea. These were complex cases. They were involving executives involved in institutions, and the Department of Justice put their back into it, brought cases, and prevailed at trial and convicted people. Some might suggest, and some have suggested in the media, that somehow this crisis is different, and that really, you know, there was some bad acting and there was some greed, but that's different, maybe unethical, but that's different than illegal. And I would suggest to you that if you look at the actions of our government, it isn't different. And our government has brought a civil case, the SEC namely, has brought a civil case against a Goldman Sachs banker, Fabrice Touré, the fabulous Fab, and he was found liable by a jury in New York in August. And what does the civil complaint against him allege? It alleges fraud. It alleges he didn't tell investors the nature and the material facts that he knew at the time that he was selling them the investment. He was found liable. Angelo Mazzillo was the CEO of Countrywide, one of the huge peddlers of these mortgages that ultimately went into disrepair and bankruptcy. He also was prosecuted, isn't the right word. He was charged in a civil case by the SEC, what with? Fraud. Fraud on investors. Fraud that he didn't disclose the risks that these investors were dealing with in selling them these mortgages that they were buying. The cases there outlined criminal conduct. It outlined fraud. But they were brought as civil cases, not as criminal prosecutions. Now, it's important to know because these are different standards, right? I mean, the criminal is proof beyond a reasonable doubt. Civil cases are by preponderance. It's important to note that the United States Attorney's Manual sets out the standards for prosecutors. And the standard it sets out is that a prosecutor should bring a case if the prosecutor believes a federal offense has been committed and the admissible evidence will probably be sufficient to sustain a conviction. Not certainty, but probably sustain a conviction. And for obvious reasons, I mean, clearly we're talking about just the confidence in the evidence here then, right? There's an allegation by our government that these people committed fraud. It was brought as a civil case. It wasn't brought as a criminal case. And so there's just seeming to be a lack of confidence in the evidence that would sustain these convictions. I think that's a mistake. Because the government believed a fraud had been committed, the government had evidence that the fraud was committed, and the government prevailed, actually, in these civil cases. And the fact that the prosecutors were reluctant to bring these as criminal cases undermines confidence in our system. It undermines confidence that juries will actually be able to figure out these complex things and be able to discern what's criminal conduct. I submit that juries are actually pretty good at figuring out what fraud is and figuring out from evidence that this is, in fact, a fraud. I think this is a very big mistake by the Department of Justice not to bring these two, and probably others, prosecutions, because it comes out of, apparently, a fear of acquittal. And, you know, the job of a prosecutor is to bring righteous cases. It is the province of the jury whether to convict or not. And that is where the department has failed in not bringing these good cases as frauds. As Hank knows, and as I know, in order to build cases against CEOs, you typically start low and work up. And when you only bring a civil case against the Fabrice, there's very little incentive for him to cooperate and provide evidence against the people further up the chain. And so while he was only a vice president at Goldman, who knows what he could have done had he been criminally prosecuted and faced some real consequences on that front in terms of providing evidence against his superiors. We'll never know because that hasn't been brought. So ultimately, I think this failure, at least these two cases and others, has undermined confidence in our institutions and undermined the fundamental belief that our system is fair. And that's why I think the Department of Justice is undersold itself in this matter. Okay?
So it is a natural human instinct when some man-made disaster or failure occurs to want to hold someone accountable. We look to our government to assign blame. We look to our criminal justice system to properly punish those who have broken the laws. The reality is, though, that sometimes our justice system cannot find and thus cannot prove that somebody has broken the criminal statutes that govern all of our behavior. I point to a number of things that you will remember in different contexts. Man-made disasters that we all have had to face, loss of life, loss of much more in terms of community, explosions, 2 space shuttles, a nuclear disaster meltdown in Japan recently. The dangers of not have been totally determined. The Great Depression of the 1930s, somewhat similar to what we're talking about today, as I'll get into. And then most recently, our recent financial crisis. There are times where it's not a question of whether the government reached far enough, as our question poses today, to ferret out and hold fraud to be account, but that simply they reached as far as they could, and they could not find enough to justify bringing charges that they were not believing, whether convinced or otherwise, that they could prove beyond a reasonable doubt. And I'm not going to reiterate what Joe's already said, but civil cases, as we teach all of you and everybody in the profession knows, are very, very different than a criminal case. I mean, it's preponderance in a civil case, more likely than not. If the government can show 51% versus the defense's 49%, they win. And to prove someone's criminal guilt beyond a reasonable doubt is not just clear and convincing, which is higher than preponderance, but is at the very top of the evidentiary chain. Whether it's 85% or 90%, it is a very, very different courtroom situation for any prosecutor facing that burden. Now, I acknowledge the obvious. I mean, if you go and Google financial fraud prosecutions right now, you will see literally hundreds of commentators who join Joe in their very strong criticism of the department's lack of prosecutions. But before some of you decide to agree to really castigate dedicated lawyers, law enforcement agents, and all the people that work at the Department of Justice for their failures, let me just briefly raise 3 points for you to consider. The first is, I think the current financial crisis is far different than the savings and loan crisis, and I think I have a pretty good idea about what happened in each. The savings and loan crisis was about people who were used to making home loans their entire career, who then were given the authority by Congress to engage in commercial lending, a very more complex and difficult way to make loans. They were often unsophisticated executives, sometimes greedy, there's no doubt about that, but who embarked on a whole new avenue of making money, often leading to insider abuse. And that's an important term, where they took bonuses that they were not entitled to, that were not authorized, that they engaged in all sorts of financial chicanery because this was an opportunity they had never had before, and they were not trained or ready to undertake it. Yes, there were risky loans, but the things they were prosecuted for were false financial reports to federal regulators, false statements in the books and records, things that the prosecutor could put out at that time in hard copy before the jury to show the falsity of the entry or the report. In Midwest Federal, I mean, that's a whole different story in terms of the complexity of it. It was 2.5 years. It was like 300 boxes of material. There was no internet communications in those days. It was a tremendous commitment, but what it was to sort out all of the criminal evidence that we had in hand to figure out what do we want to put before a jury. That still took 5 months and led to 26 days of jury deliberations. But that was symptomatic of what happened in the savings and loan crisis. You don't go and convict 1,000 people without having a whole path of damning evidence to show insider abuse and false statements and lies to the government or to the investors. That's not what the recent crisis has been about. The recent crisis has been about a combination of reckless lending, of absolute willful indifference to risk, to excessive securitization of collateralized debt. I mean, even to say it sounds, how am I going to describe this to a jury? I mean, the collateralized debt obligations were the heart of this. Taking a bunch of loans that should never have been made in the first place to people who really weren't qualified for them, bundling them all up and then selling them to other, often sophisticated investors and banks. And the economy, as long as it kept churning forward and housing prices went up, everybody's making money and happy. But when the inevitable fall occurs, it's like musical chairs. The person that was left with those mortgages in their bundle at that time suffered a huge loss. And because these institutions were viewed to be too big to fail, that was passed on by our Congress and by our two administrations to the taxpayer, and more accurately to the taxpayer's children and grandchildren, is what's happened. That is a horse of a different color than what happened in the savings and loan crisis. So where did this put federal prosecutors? For the last 5 years, these are the issues they've had to grapple with. We are in the same place as we were in the Great Depression, which lasted longer than what we've had to go through now. We had outrageous, risky behavior costing other people a great deal of money that was not clearly illegal. We had banking regulations at the start in 2008 that at best were vague, almost unenforceable in their vagueness, and clearly did not prohibit the types of conduct that Congress later legislatively put in the Dodd-Frank statute. We had an almost impossible situation where those executives, many though they were, had consulted with in-house attorneys about the programs that they were embarking on in terms of this collateralized debt. They consulted with their boards of directors. That's not something you had in the savings and loan crisis for the most part. The lawyers were kept out of it. The boards were seldom consulted. Here on Wall Street, the people were wise to what had happened, not just from the savings and loan crisis, but also the Enron prosecutions. So the regular course was to run this by the lawyers. Well, as you'll learn, if you ever get involved in this area of criminal defense, a business person, including a banker who relies on a lawyer for advice and goes forward after having fully disclosed all the issues to the lawyer, has an almost iron-tight defense to any criminal charge. It's called a good faith jury instruction. And it says that that business person, if they relied on that attorney's advice in good faith and fully disclosed the issues to that attorney, that eliminates, that certainly calls into serious doubt the government's ability to show willful participation in criminal conduct. And finally, that's what we have here. I want to, maybe sound like a crim law prof just for a minute. The standard of proof when we talk about beyond a reasonable doubt is not the only hurdle here. What's the toughest thing to prove in a criminal fraud case? Intent to defraud. Always an essential element. Has to be something the government can show was purposeful, that there was a willful decision to do something wrong, and in some cases to violate the law. It is not a question of making a horrible mistake or making a very bad business decision, even engaging in gross negligence, except for limited cases where strict liability applies. In most cases, fraud cases, gross negligence is not enough to get you to the jury, much less to try and get a guilty verdict in a fraud prosecution. So what does that mean in real terms? It means that taking a risk as a business person or as a banker, taking even a crazy risk or a big risk with somebody else's money that causes them to lose their money is not the same as lying to the government or lying to a customer or cheating in the stock market. It is not at the same level. And even if those people, as disagreeable as it may be, receive huge salaries and then bonuses on top of that to engage in this risky job with other people's money and losing people's money, that is not the same as embezzling those funds. Now, you can criticize, as we should, that the laws have not been doing their job in and of themselves, or that the Congress and the regulators have not been doing their job, either being asleep at the switch, not being appreciating the clever financial bundling that was going on. Those are all part and parcel of what any prosecutor has to look at in evaluating a case. Let me just talk real briefly about a second reason, and then I'm going to save my third point for rebuttal. Case law. I mean, there's a wise old rule for all of us as lawyers that you learn more from cases that you lose than cases that you win. And that's been true for organizations too. And the Department of Justice learned a very painful lesson that remains to this day in prosecuting Arthur Andersen, a Big Five accounting firm, in the wake of the Enron scandal. We had 4, maybe 5 people who clearly broke the law at Arthur Andersen, destroyed documents that the SEC was trying to get in their investigation. The DOJ prosecuted one of these Big Five accounting firms, Arthur Andersen at the time, succeeded in finding a charge of obstruction of justice that they could prove. The jury agreed. Even before Arthur Andersen got the sentencing, the punishment was imposed because they lost their ability to be a CPA firm, to audit public companies, and the firm disintegrated. And 28,000 people lost their jobs. 3 years later, the Supreme Court, in a unanimous decision, doesn't happen all that often these days, that they rendered 5 weeks after oral argument, a record time, unanimously reversed the conviction. But Arthur Andersen was history. It was a very difficult time at the Department of Justice. I think a lot of soul searching went on. I know it went on in the District of Minnesota about what the power of the prosecution had done in that case and later found to have been overreached. So I want to be sensitive to the time. There's a second case, though, that I'm just going to throw out because we need to talk about at some point. It's not something that I think is a justification for my position, but it's something we should all know. How many of you recognize the case United States versus Ralph Chaffee and Matthew Tannen? I'm guessing hardly anybody. That was the first prosecution in the recent financial crisis in New York. to Bear Stearns hedge fund portfolio manager and chief operating officer, charged with fraud and conspiracy. 1 month trial, jury acquitted on all charges. And that case has been remembered by everybody who goes into the U.S. Attorney's Office on Wall Street. And there's more to be said for it, but I want to be sensitive to the time. So, Joe, I'll give you some rebuttal here.
Well, I'm glad you put that third point out there instead of saving it for rebuttal. That's called sandbagging in effect. A couple of things, and I'll be brief. I say, first of all, Hank posits, and I think this is sort of the conventional defense of the Department of Justice, is that taking risks is not illegal, even if they're crazy risks. And I agree. Prosecutors are not here to judge good business decisions or bad business decisions. But that's not what we're talking about. What we're talking about is lying to people. We're not talking about complex structures and CBOs and this and that. We're talking about lying to investors. That's what fraud is. And what has been alleged by our government that Fabrizio did, he lied to his investors. He committed fraud. That's what the civil charge that was brought against him was. That is a criminal act. And so the only difference is whether or not you think you have the proof that gets to you to beyond a reasonable doubt. And I submit that that would be best put to a jury in this particular context. And Hank is exactly right that I think the Department of Justice got scared after that 2009 acquittal in the Eastern District of New York, that these cases might be too hard in a criminal context. And I agree that it would take a lot of fortitude and willingness to take risk, personal risk by the prosecutors to bring some of these complex cases and these high-profile cases. And I understand that challenge. But that's why I'm critical of some of the folks in the Department of Justice for not taking those risks and allowing a jury to make those decisions. With respect to the Arthur Andersen piece, and I think that this is a fair point, I think the Department of Justice did learn lessons following the criminal prosecution of Arthur Andersen. And the problem with prosecutions of corporations is that the penalty is really felt by the people who didn't commit the acts. The shareholders, the employees, the creditors of that organization bear the burden of the penalty, whatever that might be. Sometimes it's debarment from government contracting, and if you're a government contractor, that's essentially a corporate death penalty. And so I believe that prosecutors should be very, very careful before they bring that kind of criminal prosecution, although it might be appropriate in certain circumstances, like the SAC Capital case, which I would acknowledge is a great prosecution by the Department of Justice in an insider trading context, not the financial crisis context. But in the early 2000s, the Department of Justice was taking very aggressive stance with respect to corporations and requiring them essentially to cooperate with the Department of Justice and to basically turn over evidence against their employees, against the bad actors. And there was a lot of pushback by a lot of different quarters, legislators, judges, law schools, pushed back on the Department of Justice very hard, thinking that just wasn't fair. That wasn't fair to leverage companies like that. That wasn't fair to intrude on the attorney-client privilege like that. And I think, unfortunately, the Department of Justice has caved into that pressure, and it has resulted in their unwillingness to force companies who have clearly committed criminal acts, and they have alleged that these financial institutions have engaged in fraud and have sought to seek civil sanctions against them. But rather than really putting pressure on these institutions to provide evidence against the bad actors at the institutions, they've had to recede on those demands and simply settle for civil sanctions. And I think that's unfortunate for our criminal justice system, unfortunate for our institutions, and unfortunate for our society. Hank.
Well, he doesn't realize, but I actually did sandbag by saving one of my arguments here. And here's what I put all of you in the position of being a federal prosecutor in New York say in Manhattan, that has jurisdiction over Wall Street. And I don't think this is, it's hypothetical, but I don't think it's too far from what happens on a pretty regular basis there. You're in your office, and you are presented with a case where there has been big banks, senior executives acting recklessly, ignoring risks, putting huge amounts of other people's money at risk that is lost. They are very well compensated per board-approved resolutions. There are no hidden payments. There are no insider abuses. There is no proof of any lies to any government authority or even investors, which the big banks really don't have that often, unlike the investment firms. Government officials arguably have been asleep at the switch, whether rightly or wrongly. And finally, the executives were typically dealing with other banks and other sophisticated investors, all who had lawyers involved in the process, offering legal opinions, risk assessments, privilege obviously covering some of this. And the agents say, here are our best facts. We open up and pursue this case. You know from your experience that this will be a multi-year commitment of your time, and given the enormity of the task, it will be probably your only case you'll work on for those 2+ years. Your agents will be required to work on the case during that time. The reality is, given who's at stake, and on the other side of the table, they're going to have the best, most experienced criminal defense lawyers in town who are going to make it a challenge for you every step of the way, which is their obligation to their client. And without a cooperating insider, without someone to explain what emails really mean, or what people were saying outside of the official record, which you don't have, it means you've got to start with a 28-year-old who's a VP of a company that has tons of senior VPs and partners, prosecute him or her, and then bring the next case to start trying to approach the senior executives that you believe may have been knowledgeable enough to be held criminally responsible. That is your challenge to open this case. At the same time, you have agents who present to you 3 different cases that they have. One, a Ponzi scheme, where they clearly have somebody who has ripped off a number of innocent victims and taken their money and spent it. You have an embezzlement scheme involving vulnerable victims who have in many cases lost their life savings. And they have an insider trading case. All of these cases have much more clearly defined laws that were violated. There will almost certainly be better evidence of lying and cheating. There will be defendants who have personally gotten ill-gotten gains, not just their salary and their bonus, but who have taken other people's money and spent it. And you can do all of these cases in the next 2 years. And you obviously can't do both. And which choice are you going to make at that stage in terms of what path you want to pursue and commit all of these agents to pursue? There's a number of other things that I could say. It's interesting listening to Joe because I've felt many of the things that he has said over the last 3 or 4 years. But then I've remembered what it was like to be in the position of the prosecutors who we are so easily criticizing today. And remembering that as unhappy as I could be about the reports of misconduct, unethical conduct that were brought to me either in the corporate context or in the financial institution context, how that was not the same as people who had taken phantom stock bonuses to the detriment of a savings and loan, or people who had gone and routinely lied to a series of people where we had the lies. In the Turi case, it was a fairly close call. It wasn't like this was a slam dunk case, and that's why the preponderance standard was something the government felt they could meet. In the Talon and Chaffee case, they had emails between these two and with other people inside Bear Stearns talking about how lousy these investments were, how they were financially unsound. At the same time, they're selling them to other people. The government said, we have enough to go forward. And there were other emails, though, that the jury heard where the guy said, we think that these companies can pull it out. We think that there's some problems now, but we think that they're going to be okay in the long run. And there was no person from Bear Stearns who would come forward and say, The first emails were really what the conversation was all about. There was no cooperating insider, and the jury finally said, proof beyond a reasonable doubt, that means you would make this decision in the most important matters of your life. That's what a good criminal defense lawyer argues to the jury. It doesn't mean beyond any certainty, but it means you will rely on this for the most important decision you can make in your life, and you will be satisfied and believing that this is the right thing to do. And those juries said no, and for better or for worse, prosecutors in New York, I think still are mindful of those were good facts for the government, and we lost big. Should we go down that path again?
All right. We've got a number of good questions here. I'm going to abbreviate some of them and direct them towards one of our panelists or another. Professor Dixon, the first one is going to be for you. You suggest failure to prosecute is motivated, at least in part, by a fear of not convicting. Why do you think this is pervasive now as opposed to in the aftermath of the S&L crisis?
That's a very good question. And I think in part, this case from 2009 is a partial explanation for that. It was one where the evidence was reasonable and it was a good case to bring, and there was an acquittal. And what you have to realize is that one acquittal does not give you a guidepost as to what is a good criminal case and what is not a good criminal case. I think in part one has to look to the leadership of the Department of Justice in Washington, D.C. In terms of the lines that they drew and the priorities that they made. I mean, the reality is, notwithstanding what Hank has said, there has been a judgment by the Department of Justice that the financial institutions didn't just engage in risky behavior or unethical behavior, that the financial institutions have engaged in fraudulent conduct. That's why there's these civil cases that are brought against the major financial institutions, whether by the SEC or the Department of Justice, and they're just brought in a civil context. And I get not necessarily prosecuting criminally these institutions for the reasons I set forth, but financial sanctions against a financial institution is not a deterrent against individual behavior. Criminal prosecutions, whether there's acquittals or guilty verdicts, actually do present a deterrence to individuals that you will be held accountable even if you've got lawyers around you and even if you're acting for your institution. And that's why I think it was all the more important to bring those criminal prosecutions. And these are good people and that they're trying real hard. But I think that risk assessment was off, and that's what I'm suggesting.
I'll throw in one other quick point that I've not mentioned. Prior to 9/11 in Minnesota, I had upwards of 24 FBI agents I could call on to do white-collar cases. Most here in the Twin Cities, some outstate. After 9/11, that number dropped precipitously. The worst it got, I believe, was 8 agents. But that number has recovered somewhat, but it's never going to be what it was before 9/11 because the FBI's main priority, their number one priority, is to keep us safe. And it's counterterrorism, and it's national security work. And I'm not quibbling with that, but I'm telling you, in terms of where things at today, prosecutors can't do these cases on their own for all sorts of obvious reasons. And the complexity in terms of the witnesses and the documentation require dedicated agent resources to make them work. And those resources are not there. And you can talk to the U.S. Attorney in Manhattan, and he will be the first to tell you that despite the fact that they have brought over 90 insider trading cases in the last 4 years, so they're not asleep at the switch in New York, and they've prosecuted big fish. But they don't have the people to be able to go and spend the years of work some of these big bank cases will take to even try and make a case, much less be successful.
I would add, actually, to that, not just in terms of the prosecutorial resources, but from the regulation standpoint. Part of the way that the Department of Justice made cases in the S&L crisis is they had criminal investigators with the regulators, with the banking, who knew banking regulations, who knew where to look, and could help, refer cases for criminal prosecution. That was lacking in the 2000s. Now, I think there are still plenty of examples that I've pointed to where the government has brought criminal cases without calling them criminal cases against individuals, which is why I think I'm fair to criticize them now. But the lack of resources that our society has chosen is a fair counterpoint, and I would acknowledge that.
Okay. This next one goes to you, Professor Shea. It's on a related issue. There are a couple questions on these lines, and that is that in the S&L crisis, we saw quite a few prosecutions of lawyers, of attorneys, and the same thing hasn't been true with this more recent crisis. Why do you think that is?
Well, my recollection is some of the lawyers who were prosecuted were more business people who had law degrees, as opposed to being a general counsel and the like, but they still were lawyers, and they should have known better and advised their colleagues and their associates better. I can't go back and give you, I think, a reasonable explanation of the whole S&L situation, but I can tell you what I think the problem is now. I think that Joe alluded to this. The way that the attorney-client privilege has been handled over the last 10 years has made it very difficult for prosecutors to get to lawyers who were involved in wrongdoing unless some insider turns state's evidence and agrees to testify that will allow the government to have evidence to pierce the attorney-client privilege. And that is a process that both of us have gone through. It is laborious, as it should be. It should not be an easy thing to do away with the privilege and have the government get access to those communications, but it takes a tremendous amount of time and resources. And a lot of times, the priorities become, yes, I think the lawyer was certainly grossly negligent in the role that he or she played in advising this company, but I don't know for sure what they knew when they knew it. And unless I'm going to go down a whole separate path, which is like a mini trial, and try and get access to that lawyer's communications, I don't have sufficient evidence to implicate the lawyer. And as I said earlier, that often extends to all the business executives who come in and show you, well, I communicated with that lawyer on this point, and I don't want to get into waiving my privilege either, but their defense lawyer is in your office saying, if you don't go after the lawyer, my client is going to win at trial because I'm going to wait till we get to trial, and then I'm going to waive the privilege, and you're going to be embarrassed because my guy relied on your attorney for advice.
So can I pick up on that point? And my criticism is because the Department of Justice, I think, really, for reasons that are understandable and political, decision making, really backed away from that fight when they were confronted. And for those of you who remember this debate from the 2005, 2006 time period, my guess is if we took a vote and you put yourself back in the position, you would have all been on the side of, oh my goodness, the Department of Justice is overreaching. This is unfair for them to be going after attorney-client privilege material. And I just want to point out, I taught evidence in this classroom. If you want to promote the privilege on one hand, the reality is you are taking away evidence on the other hand, the evidence to pursue criminal justice in our society. And so that is a value judgment that gets made, but it's not all good. It's not all good, and we have to be cognizant of the choice that gets made. And I wish the department had pushed that more vociferously with Congress when Congress was coming down hard on them for using their big hammer with corporations. Because Congress wants them to go after, the insiders and the corporate personnel, but then doesn't necessarily want them to use the hammers to get the evidence that's necessary to make these prosecutions.
Okay, great. This is one, Hank, I'm going to direct to you, though, Joe, you can pick up as well if you'd like. It's an important question. Using Catholic doctrine, is it not essential that an individual in society have the opportunity to redeem themselves through reparation and formally admitting the wrongdoing and then paying the penalty? In other words, by not prosecuting, are we ignoring that higher law that people be called to account and then allowed to repent?
That's it. That's an excellent question. It kind of has a number of different overtones to courses that I'm now trying to teach. What I would say is that for somebody to ever be able to regain whatever self-respect they lost when they engaged in the misconduct, to be able to become redeemed, whether it be in the religious sense or in the personal sense, I think that you do need to have an accounting. You do need to have some opportunity to accept responsibility and to try and make amends for it. But, and it's always the but, we have a criminal justice system that says every one of us in this room is presumed innocent of any allegations made against us. And it is the government's sole obligation to try and overcome that presumption. And as long as somebody takes the position, whether they believe it or it's because their attorney advises it or whatever, that I am not in a position to accept criminal responsibility for what happened because it was an economy that nobody could have seen in advance, the meltdown that occurred, because I was part of a large organization where everybody was acting in concert. And it was not me acting as a rogue offender, but part of a group effort where we all joined together, and yet the government is coming to me and saying, you have to be the person to be held to account. I think that's a strong countervailing concern.
Just to pick up on that, I mean, I think the issue here is that the Department of Justice has gone after the institutions rather than the individuals. And the reality is the institutions commit bad acts through individuals. And so you need to deter individuals from gaining in that kind of activity. Unlike when the S&L crisis came around, and we've talked a little bit about the challenges of obtaining evidence because of privilege and other things, emails really exist today and existed in 2007 and 2008 and were the basis for the prosecutions of Toure. And that really shows not that this is just risky behavior, but that the people on the inside knew what they were telling people on the outside wasn't true. And that's why I remain convinced that criminal prosecutions could have been made. Do I know whether they would have been convicted as opposed to acquitted? I don't know. But I don't think it's for the place of the prosecutor, so long as you have sufficient evidence that you let the jury decide that. And I actually have quite a bit of confidence in the juries, and I think that the concerns coming out of the Bear Stearns prosecution in 2009, which resulted in acquittals, got way overblown in terms of the minds of some of the leadership.
All right, Joe, I'm going to direct this one to you. It's about the use of prosecutorial discretion, and that the White House indicated that one of the reasons that they avoided charging individuals was that it might impede financial institutions in their ability to hire sophisticated executives, which raises problems of immunizing those people from the kind of repentance we just talked about. Do you see that as problematic?
Yeah, I'm not familiar with that quote, but I obviously find it very problematic on a whole host of issues. I mean, if you can only be an executive if you can be not engaging in any kind of criminal conduct that you want without the possibility of prosecution, I question whether you're the right executive for that institution. I know that there was a lot of sensitivity about, I mean, we were in a very precarious position in 2008. I mean, I would be foolish not to acknowledge that. And I think that there was a lot of care given to financial institutions. And I get the value judgment that got made there. I just think that value judgment has been overblown and put in the wrong spot, because I think you need to hold those people in particular accountable if you can get evidence against them.
All right. Hank, this one I'm going to direct to you because it's a critique of your position, I think. And that is, does too big to fail also mean too big to prosecute?
That's been a hotly debated item in the last 7 months, ever since the Attorney General earlier this spring made comments suggesting that as recently as this year, that some institutions might be so big that to prosecute them would risk a serious financial situation for this country and even for the world. And then I think there were later efforts to try and redefine or at least modify that position. Here's the bottom line. I mean, the department's position, I believe today, is and should be that nobody is too big to be held to account and nobody is too big to prosecute. But we have to be mindful of collateral consequences, and that's something that prosecutors, frankly, have not paid as much attention to as they should have. Everybody in this room who wants to be a prosecutor at some point in their career should go and read that Arthur Anderson decision and be mindful of the fact that pursuit of principle, as appropriate as it may be, may cause a great deal of harm to people who are doing the right thing and showing up for work every day with the right value system in place. And that's why between institutions and individuals, I agree with Joe. I mean that it is far more appropriate to be pursuing individuals if you can make the case. I have some sense, though, that in New York today, given the resources that they have available, that if they get faced with that proposition I gave to each of you about which case to pursue, or a case versus cases, it's not a hard decision to make. If you can't do both, where you know you can bring justice to some individual victims, maybe get some of their money back even, versus pursuing a big bank or senior executives on a case that may well fail out of the box, how many of you would make the decision to go down the road of pursuing the big bank and its executives?
So let me pick up on that. I agree with some of what Hank says. The SEC was highly criticized for settling civil cases with financial institutions without an admission of any wrongdoing on behalf of the financial institution. You know, and it's a pretty standard civil practice, right? You know, you settle cases, you don't have to litigate. Boy, what's wrong with that? That's very efficient, isn't that? We get to move on. I would suggest that government plaintiffs, whether it's in the prosecution realm or in the civil realm, have an obligation that's more than just being efficient, although I acknowledge I was efficient when I was at the U.S. Attorney's Office as well. But particularly where you have these big issues on societal harm, they need to act on behalf of the public to extract from these large institutions more than just a check, because the check isn't enough. And whether that's admissions of wrongdoing or consequences to employees and bad actors, those are the things that you want to see, is actual consequences to individuals, because that's what gets the deterrence message out there. And that can come in a lot of different forms. Criminal prosecution should be one of them.
All right, this may be our last question. I'm going to direct this to you, Joe. As Professor Shea briefly mentioned, the government allowed banks to issue loans to persons likely or certain to default, but the government also mandated that banks issue such loans in certain situations. And the Bush administration encouraged development of some of these things that happen. Given that, doesn't that cut against the argument for more aggressive prosecution?
Well, no. Let me give you a better answer. The reality is what I understand from sort of the publicly developed record is that the banks, Citibank, for example, there was a officer of the credit department at Citibank who would write emails, internal emails, to the executives at Citibank saying, we are violating our own credit policy regularly. 60, 70, 80% of our loans are not consistent with our own guidelines. And you know, to what extent was that really told to investors? And you know, we have this credit policy. We have this great credit policy that you can rely on, that we've done our diligence, we've done our underwriting, here is our policies. Well, the reality is the policies really didn't mean much because there were so many exceptions. And so I think actually that there were lies to people. Ultimately, you need to show lies. In any good criminal prosecution, you need to be able to show that somebody lied to get money. And it all comes down to that. And I think actually there were plenty of cases where people lied, and the emails actually showed that.
Can I make a real quick statement? I
I got the last word.
All right. The Great Depression, virtually no prosecutions. There were a couple failed prosecutions, acquittals of major bank figures that I'd be happy to share with you after we finish here. But what did happen? The SEC got created. Here, we could pursue the prosecutorial effort if people want to put the resources into it. But what's the far better societal solution? Higher capital requirements. Regulations that will actually regulate the risky financial derivative market. Make laws clear so that when people then violate them, prosecutors can say, that's a case that I can bring. Thank you.
Thank you. Before I ask you to join me in thanking our stellar panel, I have just 2 points. One is, Same place, same time, December 3rd. Our next program is going to involve the Dean of our School of Theology and a Professor of Entomology from the University of Minnesota discussing ethical and scientific impact of genetically modified organisms. So please join us again. My second point is, don't those of you who are not alums of this law school wish you had been able to learn criminal law from Professor Osler, Professor Shea, and Professor Dixon? I think we all learned a lot, and I please ask you to join me in thanking our three panelists. Please speak.
Wilbur Fauché. Thank you. Wilbur Fauché, prosecuted by the United States Attorney's Office in 1831.
That's right.
Fauché of Fauché Tower?
As in the Fauché Tower.
It was right. Because I'm thinking about the founder of City.